The second subheading is the issue raised justiciable? In my opinion, the authorities discussed during the submissions vouch the following propositions. The exercise of some prerogative powers in some circumstances is justiciable. In other cases, it is not. The court's role in relation to prerogative powers is dependent on the nature and the subject matter of the power or its exercise, particularly on whether the subject matter is justiciable. Whether the exercise of a prerogative power is reviewable depends on the subject matter and the context of the power and of the challenge. Some functions exercised or decisions taken are non-justiciable. Among them are matters of high policy and political judgment. The court does not have the tools or standards to assess the legality of such matters. That is political territory and decision-making which cannot be measured against legal standards, but rather only by political judgments. The courts will not seek to superimpose legal controls on such matters. Rather, the accountability for them is to Parliament and the electorate. I am not persuaded that any of the matters relied upon by the petitioners or the Lord Advocate result in the claim being justiciable. In my view, the advice given in relation to the prorogation decision is a matter involving high policy and political judgment. This is political territory and decision-making which cannot be measured against legal standards, but only by political judgments. Accountability for the advice is to Parliament and ultimately the electorate, and not to the courts. I do not accept the submission that the prorogation contravenes the rule of law and that the claim is justiciable because of that. In my opinion, there has been no contravention of the rule of law. The power to prorogue is a prerogative power, and the Prime Minister had the vires to advise the Sovereign as to its exercise. The Executive is accountable to Parliament and the electorate for the advice to prorogate. Parliament is the master of its own proceedings, rules and privileges, and has exclusive control over its own affairs. The separation of powers entails that the courts will not interfere. It is for Parliament to decide when it will sit, and it routinely does so. It is not for the courts to devise further restraints on prorogation which go beyond the limits which Parliament has chosen to provide. Parliament can sit before and after the prorogation. It has recently, in the Northern Ireland Executive Formation Act 2009, Section 3, exercised its legislative power to make provision about periods when it should sit. Finally, I should say something about the reasons for the prorogation given by the respondent. Even if, contrary to my view, the claim is justiciable, in my opinion, the context in which those reasons would fall to be assessed would be that political judgments may be relevant and legitimate considerations. On the basis of the material which I have seen, I am not persuaded that the reasons for the advice were unlawful. I shall refuse the petition.